Hi there, I'm Savannah Mexto with Mannor Law Group, and I'm excited to welcome you to another webinar Wednesday with esteemed elder law and estate planning attorney, Robert Mannor. This week's webinar is for anyone who has been through or is going through a divorce. Let's face it, divorce is hard and filled with a lot of life change in a very short amount of time. But what do these changes mean for you in your legal planning? Stay tuned today to find out. Now, before I pass the mic, I'd like to cover just a few housekeeping details. Now, Attorney Bob Mannor, your host today, even though he is an attorney, today's webinar will not give specific legal advice. If you do have a question about your unique situation, please contact us after the webinar. Now, if you do have a general question during today's presentation, please use the question box. We will go ahead and save time at the end of today's presentation to review any questions that you have during the presentation. But if for some reason we don't get to your question, we will contact you after the presentation. Now, lastly, remember that today's presentation will be recorded and the replay will be sent out tomorrow so that you can share that with your friends, family, or anyone who you think could benefit from hearing this information. Now, why should you listen to what the folks at Mannor Law Group have to say? First, note that we're nationally recognized and respected elder law and estate planning firm. All three of our attorneys are accredited by the Veterans Administration to assist veterans with claims and appeals. Attorney Bob Mannor is nationally board certified as an elder law attorney by the National Elder Law Foundation. He's honored in 2020 as both a super lawyer and a leading lawyer by those peer review lawyer rating organizations. Bob is currently on the executive board of the State Bar of Michigan Elder Law and Disability Rights Section and past president of the National Academy of Elder Law Attorneys, Michigan chapter. Lastly, Mannor Law Group has been honored by readers of our local paper as the best or favorite law firm for the last 8 years in a row. Now, without further ado, I'd like to welcome Attorney Bob Mannor.
Hi, folks. We're going to get right started on this, and it is an important topic. It's one of the things that I think folks kind of forget about when they're going through the struggle of a divorce. There's lots of things to think about, obviously. So it's difficult to be thinking about, okay, well, does that mean I need to update my will? Do I need to make sure I have somebody in place for power of attorney? You know, how do I set things up for the future so that, especially if I have kids, that things are going to be set properly? It is one of those things, though, that is one of the big red flags. So I'll have folks come in, and it's always a question. People will often have the question, hey, you know, my situation seems very simple. I don't have millions of dollars. It's nothing overly complicated. But as soon as I hear that they either there's been a divorce in the past, especially if there were kids, then I know that there's unique estate planning issues there. And let me try to help you walk through the thoughts, the reasons why that is, because a lot of folks, they figure, okay, well, hey, I got a will, or even if I don't have a will, I pretty much know everything's going to go to my kids, right? Isn't that the way it's going to work? Well, not necessarily. When there's a divorce, we almost guarantee that we're going to need some very clear and written estate planning. You're not going to typically want to rely on the laws that the state has written for those folks that don't write a will or that don't write a trust, because they sometimes result in things that are unexpected. So let's start off with some of the basics here. It's so important. One of the things that we don't think about, especially if you have young children, that I know when we're married, it's a conversation that comes up. Oh my gosh, what would happen if we were both gone? Who would raise the kids, right? And so that's a conversation that married couples have often, and sometimes they act on it and sometimes they don't. Just as an aside, by just thinking about it or talking to your sister or your parents or your whoever it is that you'd want to raise the kids, that's not sufficient. Or writing a note on a piece of notebook paper before you go on vacation, that's not sufficient. The only way to specify who would raise your kids in the event that both parents are gone is through a will. That's the only legally enforceable way of doing that. You have to have a will. Even if you have a trust, you have to have a will specifically for that purpose. And so even if you did that as a married couple, then people think, well, okay, now we're getting the divorce. If something happens to me, God forbid, something happens to me, my presumption is the other parent would raise the kids. Well, there's a couple things to think about there. It's impossible to predict the future, right? It's impossible to know what is going to happen the next year or the next year or the next year. And so just like we never know when any of us are going to go, when any of us are going to die, we don't know what's going to happen with regard to the other parent. And it's at least something worth thinking about to specify, boy, if I were gone, am I comfortable with their will, the other parent's will, or the other parent making the decision, full decisions, or not at least expressing my desires about who would raise my kids? And so it's just something to think about, because number one, there could be some reason why the other parent is not able to raise the kids, or legally not allowed to raise the kids, or any number of things like that, or they're not going to be in one place, or any variety of things, right? And then the other possibility is it's possible the other parent could also pass away. And so you want to make sure that you've stated your wishes, that if you want to make sure, sometimes we say, okay, well, I wouldn't want his parents raising my kids, or I wouldn't want her parents raising my kids, or I wouldn't want her sister, whatever it is, his brother raising my kids, whatever it is. If there's people we wouldn't want raising the kids, then you better specify who you would want raising the kids. So that's a really important thing after divorce if there's children involved, minor children in particular, right? So now, what about if your children are raised? What if your children are adults? Is there still any issues there? Well, it depends on, what's an adult? And I'm joking about that because we kind of know what an adult is. Typically, is somebody over 18, but when it comes to money, are we comfortable with the possibility that if your child is 18, that they would be in charge of spending whatever money from whatever life insurance proceeds, or the sale of the house, or whatever money you had gathered or had come into the estate through life insurance or through other means, or even through a lawsuit settlement if there was a car accident, if you died in a car accident, who's going to manage that money? Is an 18-year-old in a good position to be able to make wise decisions and have the life experience to manage some of money, whether it's $10,000 or $1 million, right? Typically, there are 18-year-olds, I'm sure, that would make wise decisions, but I guess it's not the majority of them, only because they don't have the life experience. They don't have the ability. Maybe they would seek out some advice, and we would hope that they would. But it might be something to think about to make sure that we have things in place for who would manage that money, whether it would be a relative of yours, or whether it would be the other parent. And that's where it really comes down to. This is one of the things that I think most people who have gone through a divorce haven't thought through this part of it. And that is, if you don't have a will, if you haven't specified who's going to raise your children, or if it's kind of expected that the other parent would raise the children and they're under 18, who are they going to put in charge of the money that's supposed to be for the benefit of those children? So let's say you have a life insurance policy. Let's say you have a house and the house is sold, and that money would be set aside for the children. Who would be put in charge of that? Well, we don't really know what the court would do, because if it's a will or if there's no will, and you haven't specified who would be in charge of that money, we don't know. We don't have an answer. But I think there's a reasonable chance that the court would say, well, the mom is raising the kid, so let's put her in charge of the money. The dad is raising the kid, so let's put him in charge of the money. There's not an obvious other person to put in charge of the money. We don't want to have this conflict between the grandparents and the mom, or the grandparents and the dad, or the aunt and the mom, or whatever it is. So it's at least reasonable to think that the court might, if you haven't specified who, put your ex in charge of the money. And some of you may say, well, that's not such a great idea. That might not be what I want. I want to make sure, this is why I have life insurance. This is why I've worked so hard to pay down my house, or to put a little bit aside in my IRA, or whatever it is. I want to make sure that if something happened to me, the kids are going to be taken care of. And I really wouldn't want my ex to be in charge of that money, because I just wouldn't trust that they would make the right decisions with regard to that money. And if you don't specify whether it's through a will or a trust, I mentioned earlier that who raises the kids is always going to be determined by the will, but who handles the money can be done through a court process through the will, or it could be done through a trust. And honestly, the trust is often a better option because it builds in more flexibility, makes it so that there's less court involvement if that's something that you would want in that particular case. So those are some of the key elements of when we think about if they're younger children, minor children, or young adults, okay? But there's other issues to think about this. It gets even more complicated. So I have folks come up and they have been, I do lots of classes, or at least I did when people got together in a room together. But so when I would do these classes, I'd have lots of folks come up and they say, you know, we've got just kind of a simple life. We've got a house is paid off, got a little bit of life insurance, got a little IRA, maybe, you know, maybe they're getting close to retirement, maybe they are retired. And they say, we think everything's fine. And we were thinking about doing a will, or we have these wills from 30 years ago, and everything should be fine, right? And you know, one of the questions that comes up is, well, tell me about yourself. Well, you know, she has 2 kids and I have 3 kids, and I say, okay, now we're getting interesting here, because if it's not the first and only marriage and the kids are all from that marriage, now we've got some estate planning issues that we've got to talk about. And so I'll have folks that are, you know, later in life in their 80s that will come up and say, well, it should be fine and we have a simple life. Well, it's not estate planning simple if you have separate kids, if you have a blended family, whether it's, you know, his kids or her kids, or even if only one spouse had kids. Because when you think about it, lots of folks will come in and they say, well, when I die, I want to make sure my spouse is taken care of, so they're going to get everything. But anything that I had, my IRA and my share of the house and my money, that's all going to go to my kids when both of us are gone. Okay. It's not. It's not going to go to your kids when both of yours are gone. It's going to go to whoever's kids of the parent that lived longer. Okay, between the 2 spouses, whichever lives longer, you're rolling the dice, and whichever lives longer, that family is going to get everything. Because what happens, you know, people might have been married for 20 years, 30 years, whatever, but they had a previous relationship or a previous marriage. And what happens is, after many years of marriage, they say, well, of course, we're just going to want to make sure that my spouse is taken care of. So when whoever dies first, the surviving spouse needs to have access to everything. They need to, you know, of course they should still be able to live in the house. Well, yes, I would want them to have access to my IRA, to my savings account, to my investment account. Maybe I even put them joint on my savings account. Maybe they're joint on my house. So they're automatically going to get those assets. So if you don't have an estate plan in place, what's going to happen then? By operation of law, not because of the evil stepmom or the evil stepdad. You know, this isn't Disney movies. This is by operation of law. Whichever spouse lives longer, their kids are going to get everything, and the first spouse to die's kids won't get anything by operation of law. And this happens so often, and people have all these horror stories about it. And you know, sometimes I imagine that there was bad feelings in the family, and the spouse that survived intentionally cut out their spouse's kids. Sometimes I think it just happened. That's just by operation of law, that, okay, we have a house together, we have this investment account together, we have this bank account together. I list my spouse on my IRA as the beneficiary. I list my spouse on my life insurance as the beneficiary. Oh, I've got my kids as the backups, though. I've got my kids as the backups on the IRA beneficiary. But you got to think it through, okay? So you got your spouse is the primary beneficiary. You die. Does it matter who the backup is? If your spouse is still living, your IRA, your life insurance, all of that is going to go to who? It's going to go to your spouse. So does it matter if there's a contingent or backup beneficiary? No, because you died first. And so now you died first, everything goes to your spouse. What happens when your spouse dies? Even if they died 3 months later, 6 months later, what happens to everything? It's going to go to their heirs. Your kids are going to be cut out completely. Okay, so sometimes when we're talking about this from an after divorce standpoint, so you've just gotten a divorce or you've gotten divorced in the last few years, we start to think about this from the standpoint of, let's maybe think about estate planning, even if we haven't gotten remarried. Let's start thinking about estate planning to make sure that we're prepared if we ever did get remarried, right? So that we can kind of line things up. So one of the things that folks will do, and I'll have folks come in on this all the time, and they say, well, yes, but it's fine. Bob, we've got this covered because before we got married 30 years ago, but because we were both married before and because we both have kids, we decided to do a prenuptial agreement. Great, probably a wise decision. So we look, actually, sometimes I don't even need to look at the prenuptial agreement because I say, okay, well, we'll look at the prenuptial agreement in a second, but let's look at the assets. So they have this prenuptial agreement that was supposed to define what's going to happen when one person dies, to make sure that there's clarity as to what the surviving spouse is, how we're going to protect the surviving spouse, and as far as living arrangements and money and all of that. And then secondly, it's often we'll say, well, but my kids are going to be able to get this share, or it can arrange that, just have specifics of what would happen if there was a death, what would happen if there was another, if that relationship ended in divorce. But what happens after 5 years of marriage or 10 years of marriage or 30 years of marriage? What usually happens, so I've had lots of people come in with prenuptial agreements, and what usually happens is I look at their assets, and their assets don't align with the prenuptial agreement. The prenuptial agreement basically says, hey, we're going to keep everything separate, and my spouse will be able to live in the house, or whatever the scenario is, but we're not going to commingle assets. Because what happens if you commingle assets, regardless of what the prenuptial agreement says? You commingle assets. If both names are on the house, both names are on the bank account, both names are on the investment, you list your spouse as the beneficiary on the life insurance, you list your spouse as the beneficiary on the IRA and the investment account. What is going to happen? Does the prenuptial agreement take precedent? Does the prenuptial agreement get followed? No, it does not, because it's a joint asset. It's already your spouse's asset. If your spouse is the beneficiary on the life insurance, it's their asset, okay? And what that means is then when they die, where's that money going to go? To their heirs, not to your kids. But you say, but my prenuptial agreement says it's going to go to my kids upon my, when we're both dead. Yeah, but that's you've ignored you might as well tear up that prenuptial agreement, because the idea of the prenuptial agreement is you've got to keep separate assets. You've got to keep separate assets. And so one of the things we talk about there is often we're going to recommend that each spouse should have a trust. And the idea is that, okay, we can make sure that we're living as a married couple, and it's almost like we're commingling assets. We have a house together, but half the house is in one trust and half the house is in the other trust, or the house is only in one trust and it lays out the rules about how that the spouse gets to live there with rent free or whatever, and that maybe even that they could sell that house and buy a new house with the proceeds. But ultimately, after both spouses die, the trust could allow that money to end up going to divide up in the way that we want to, either divide it up between both sets of kids, or if all the money came in from one spouse, we could say, well, after both spouses are taken care of, the proceeds from the sale of the house after both spouses have died, or from the life insurance, or from the IRA, or from any of these other assets, after both spouses have died and whatever they haven't used, that's going to go to the divide up in the way that we've agreed upon. So if one spouse comes in with $1 million and the other spouse comes in with $10, and the spouse that came in with $1 million said, I'm going to make sure my spouse is taken care of. I love my spouse. I'm going to make sure that they're well cared for the rest of their life. But I'm not a fan of my spouse's kids. And so I want to make sure my $1 million, or whatever's left of my $1 million, upon my death goes to my kids and not to her kids who don't like me very much and never treated me nicely. Well, you can do that in a trust, but you can't do that in a will, and you can't do that it won't happen automatically, no matter how many contingent or alternate beneficiaries you have on that. And a lot of times you can't even, it doesn't even work very well with the prenuptial agreement, because the prenuptial agreement basically deteriorates over time as you start commingling your assets. And so there is a way to do this, to say, okay, yes, of course I want to take care of my spouse. Of course I want to make sure that they have a place to live, and that they have the resources that they need, and they have access maybe to all the money even. It's, that's certainly an option. But that whatever money they didn't need, whatever money we didn't use, whatever we get from the sale of the house or the life insurance proceeds or whatever else, that's going to go back after we're both dead, and that's going to go to my children, rather than rolling the dice and saying whoever lives longest, their kids get everything. And that's what happens so often for people that haven't thought this through or done estate planning. Every once in a while, I'll even see attorneys that will draft it that way, and I think, oh my goodness, how did that happen? You knew that these folks were married and they had separate kids, and you end up still drafting a legal document that didn't think through, okay, this isn't just about what happens when you die. This is about what happens when you die, and for the 30 or 40 or 50 years after that, possibly when your other spouse dies, what if the spouse remarries, all of these other things. So this is a really important issue, to make sure that we're not disinheriting our children by accident. And I do, I joke about the evil stepmother or the evil stepfather. I think that was ingrained to us with all the Disney movies, but the bottom line is, maybe that's true sometimes. I hear these stories, and I'll relate the story to folks that come in and talk to me. I say, well, it might have just been by operational law. And often it's, no, it was because they were a bad person. Well, I don't know, maybe they were, maybe they weren't. But what I do know is they didn't have to intentionally disinherit his kids, or they didn't have to intentionally disinherit her kids. It might have just happened by operation of law because they didn't plan properly. So whenever I have a family that has a divorce in the past, either side has a divorce in the past, especially if there were children from the first relationship, then it is so important to really think through these things and make sure that we have a plan in place, and that we have a trust that's going to be able to manage those assets after the death of the first spouse, and make sure that it goes where we want it to go upon the death of both spouses. I have one final issue I want to talk to you about. And the final issue I want to talk to you about is, occasionally, actually pretty frequently, I'll have folks come in and the wife will say, well, my stuff, everything's going to go to my spouse if I die. But then my stuff is going to go here. And then the husband says, well, I want everything to go to my spouse, but then my stuff is going to go here. In other words, basically, let me see if I can rephrase that a little bit, because that sounded similar to what I was saying before. What the spouses come in and they say, well, my will's going to have everything go to a charity. And the other spouse says, well, my will's going to say everything goes to my brother or sister. Let's say neither of them had any children. We got a problem there. Or they do have children, and they say, well, my stuff is going to go to my children. My stuff, not my stuff, but my will is going to say everything 100% goes to my children. And then the other spouses will says, well, everything goes to my children. Problem is, you got commingled assets. Okay, so it's not going to work that way. Basically, you're rolling the dice again and saying, who lives longest? Who lives longest? Their family gets everything. Their heirs get everything. Their preferences get followed. And I don't think that's what anybody wants. And that's where I have to do a little counseling. That's the, they always call attorneys attorney and counselor at law. That's where the counseling comes in, because I got to say, all right, let's figure this out. We've got to come up with an answer that you both agree on, that say this, because they come in, they have commingled assets. Everything's commingled. They have a house together. They have a bank account together. They have investments together. Everything is commingled. And yet their wills say separate thing, or they intend, or they want their wills or their trust to say separate things. And what I say is, look, if you're going to commingle, if you have separate assets, the one spouse has a set of assets and we don't commingle them, the other spouse has a set of assets, then don't commingle them, which in my view is the best idea. Let's keep it that way if we can arrange that, if we can afford that. Let's just keep the assets separate. That's the best answer. Great, you can do your own planning, perfectly fine, no problem with that, right? The problem is most people come in, they've commingled their assets. They have a house together, they have a bank account together, they have an investment account together, and then they say, well, yeah, but my will is going to say this, and I'm not willing to sign a will that says anything's going to go to his kids, or that anything's going to go to that charity that I don't like, or that political party I don't like, or whatever it is. And that's where I've got to counsel them and say, okay, you guys got to come up with a plan. And whether you say, all right, you get to decide 50% of the assets and you get to decide 50% of the assets, but ideally you're coming up with a plan together that you're both going to consent to, and we both kind of got to compromise perhaps, or just agree that you're going to agree that, you know, they get to decide 50% of it and you get to decide 50% of it, or change those percentages, or whatever the scenario is. But we got to do some counseling to figure that out, because we don't want to have it be where each spouse has a separate plan written in their power of attorney when we have joint assets. Because now we're just rolling the dice. We're just gambling to say, okay, whoever lives longest wins. And that's exactly what that kind of estate planning would be, is whoever lives longest wins. They get their way. And even if it's for they live 30 days longer, or they get in a joint car accident, you know, literally it's the luck of the draw as to which person sat on which side of the car. So the bottom line is, anytime there's a divorce, especially when there's children, but even when there's not children, anytime there's a divorce, especially if there's remarriage, you've got to have thought through very specific estate planning. It does go to one other issue that I want to mention, and that is that it's important to have an estate planning or elder law attorney that really does think about this stuff all the time. I always, you know, talk about the importance of using people that are experts and know what they're doing. And I use the example of, you know, getting your taxes done, or having your plumbing work done, or electrical in particular. You know, I always say, you know, I might be able to fix a few things around the house, but I'm not going to try to rewire something. It's you know, there's just too much risk there. And the idea is the same thing with a lawyer. That if you have a lawyer friend that does personal injury, or a lawyer friend that does traffic tickets, or a lawyer friend that does bankruptcy, they could I'm sure they could draft a will. I'm sure they could draft a trust, but they're not going to have thought through all of the issues as somebody that focuses their entire practice on this. I really think that it's an overlooked part of this. But I mentioned, you know, this is the thing I'm thinking about for 40 to 80 hours a week. This is the type of thing I'm thinking about. You may have thought about it for a few weeks or a few months. I've been thinking about it for 25 years, 40 to 80 hours a week for 25 years. And I've thought about a few things, and I've seen a few things, and I know how to prevent that. I know how to think those through to make sure things are going to go the way they're supposed to. And that's why I don't let somebody convince me to handle their law case that isn't related to the practice area that I practice. And I wouldn't recommend that you use an attorney that doesn't have this as their primary practice area, especially when there's red flags or complicated things like if there's a divorce or a remarriage or separate kids, you know, things like that. So hopefully this was useful to you. We're going to see if there's any questions here today, and then we're going to talk to you about how you could get further information. And so I think Savannah's going to come back on and give you some instructions here.
Thanks, Bob. We don't have any questions today, so if you do have a question, I do encourage you, announce the time to go ahead and put that in the chat, in the question box. I'm also going to go ahead and put in the chat a word for you to get in touch with our team. So if you've watched this webinar, or maybe you've watched another webinar Wednesday in the past, and you're thinking, man, I really do have a question, I'm not sure about this, or I just want to know more about that, that's what we're here for. So I encourage you to give us a call at 810-694-9000, or you can go ahead and use this link that I'm going to put in the chat. This link will allow you to choose a day and a time when a member of our team can reach out to you and give you a call. They can go over the questions and concerns that you have. You can ask questions about our firm. You know, it's a really good opportunity for you to get to know us and for us to get to know you. So I have gone ahead and put that in the chat. I'll also be sending an email to you maybe in about 10 minutes. You should have that in your email inbox. That email will also have that link for you. It'll have our phone number, so that if you do want to get in touch with us, we are available and it's easy for you to do that. So thank you again for joining us today. I look forward to having you next week. Have a great day.